Good morning, ladies and gentlemen. A very warm welcome to you to this conference on Companies Bill 2013 or Companies Act 2013, apparently it has been signed by the President yesterday. We have with us the Honorable Chief Justice of Bombay High Court, Shri Mohit Shah ji, and other esteemed dignitaries. I request the Honorable Chief Justice, the President of Indian Merchants Chamber, Mr. Shaunak Thakkar, our senior most trustee, Mr. Vishnu Haribhakti ji, to light the lamp and begin today's proceedings. Thank you. Please take your seats. And I request Mr. Shailesh Vaidya, President of the Merchants Chamber, to give his welcome address and introductory remarks.
Honorable Chief Justice, His Lordship, Mr. Mohit Shah, dignitaries, guest speakers, ladies and gentlemen. A very good morning to all of you. Good morning. On behalf of the Indian Merchants Chamber and on my own, I have immense pleasure in welcoming our Chief Guest, Honorable Chief Justice, Shri Mohit Shah. I have also pleasure in welcoming distinguished speakers at today's conference and all of you, the participants who have made it convenient to attend this conference in such a large number. It is indeed a privilege to introduce to you the Honorable Chief Justice, Mr. Mohit Shah. Mr. Justice Mohit Shah was born in the year 1953 as son of a district and sessions judge. Did his schooling at Baroda, Surat and Amreli and pursued his higher education at Maharaja Sayajirao University at Baroda, from where he obtained the degree of Bachelor of Arts in Political Science with first rank. In 1976, he secured the gold medal at his LLB examination by securing first rank and started his practice in the Gujarat High Court, making rapid strides in constitutional, civil and corporate matters. He was elevated as a judge on the bench of the High Court of Gujarat in the year 1995. He was elevated as a Chief Justice of the High Court at Calcutta in the year 2009, and thereafter he has assumed the office of Chief Justice of Bombay High Court on 26 June 2010. He has published several articles, attended and addressed many lectures and conferences on various aspects of diverse laws. Honorable Chief Justice Mr. Mohit Shah has been an ardent supporter to the cause of alternate dispute resolution and has always supported the Indian Merchants Chamber in all the endeavors, including training seminars for promotion of arbitration, mediation and conciliation. Many of you are already aware that our chamber, which will be entering 107th year next week, has multifarious activities. The Indian Merchant Chamber, as a premier chamber, has always served with an ever-increasing zeal the cause of Indian trade, commerce and industry, especially in terms of global trade and investment. IMC plays a major advocacy role on a wide range of issues affecting the growth and development of businesses and on key policy and implementation matters. We lay a lot of emphasis on public education and awareness. Creation and conduct of many programs are for meeting this end. This conference is in pursuance of the above objective. In fact, I am happy that our law committee is now planning to have several legal awareness seminars and meetings. Now coming to the subject, all of you are aware that the Companies Act 1956 was enacted after independence to replace the Indian Companies Act 1913, then in force. After independence, the country set the objective of having a socialistic pattern of society and adopted the model of mixed economy with more emphasis on controlled economy. The emphasis in the Act of 1956 on control of the government and bureaucracy on large number of matters and provisions. More than 56 years passed since the Companies Act 1956 and many changes have taken place in the national and international economic environment. The economy has become more diverse, complex and dynamic. The number of companies has gone up from a mere 30,000 in 1956 to approximately 13 lakhs as of 30th June 2013. Changes in the Companies Act 1956 became necessary. The Companies Act 1956 has been amended as many as 24 times since 1956. Looking at the proliferation and diversity of amendments which have been made to the 1956 Act, need was felt to rectify the law. Need was also felt to delete redundant provisions and to delay the procedural aspects from the substantive law. The government then constituted an expert committee to make recommendations in respect of the new company law under the chairmanship of Dr. J.J. Irani as far back as in 2004. Based on the recommendation made in the said Irani report and considering the inputs received on the concept paper issued by the government, a new bill was prepared and introduced in the Lok Sabha in the year 2008. However, on the expiry of the term of the Lok Sabha, the said bill lapsed and was again introduced in the year 2009. The bill was ultimately passed by the Lok Sabha on 18 December 2012 and after considering the recommendation of the Joint Parliamentary Committee and thereafter passed by Rajya Sabha on 8 August 2013 after renaming it as the Companies Bill 2013. Now, ladies and gentlemen, the President has yesterday given his assent and therefore what we will be discussing today will be the Companies Act 1913. As this is 2013, yes. And as this is no more a bill, we are just waiting for the formal notification, which is a mere formality. The Companies Law, amongst other things, the new Companies Law, now provides for various aspects of internal governance of corporate entities and a framework for their regulation. The Act seeks to restrict the layers of investment companies to two. Also, prior approvals are required for investment beyond prescribed limits. It also provides for reduction in government control over internal corporate processes. A new entity in the form of one-person company has also been provided. A speedy incorporation process has been prescribed. A number of provisions have been made for transparency in disclosures and government and relating to management and administration, accounts and audit. Provisions have been made for appointment of professional liquidator, and summary procedure for liquidation of smaller companies has also been provided for in the Act. Provision has been made for appointment of woman director on the board of directors. Independent directors are stringently defined and their tenures are now limited. A new concept of corporate social responsibility has been introduced in the Act. The Indian Merchant Chamber welcomes this path-breaking law, which will assist in revolutionizing the administration and management of corporates in the times to come. We commend the new Act as it aims to meet with global standards vis-a-vis disclosure requirements, increase democratic rights for shareholders, self-regulation and accountability. However, as with any new legislation, there are some hurdles, some difficulties, and this conference may also focus on the same. Questions on necessary loans to subsidiaries to be allowed without interest, arm's length pricing, layers of investment companies. Further queries arise as to how independent are independent directors. How many persons will be available to be appointed as independent directors? In theory, yes, because there are no qualifications to become an independent director. But in practice, once you tell the prospective person of the responsibilities, he might refuse. Also, the question of corporate social responsibility, whether compliance with CSR is mandatory. On accounting, there are some differences on the definitions as per the accounting standards and as mentioned in the Act. Parity in the definitions is required. Friends, this conference aims to educate you on the provisions and complexities of this milestone law. We are grateful to all of you and more particularly our expert speakers for having accepted our invite to address this conference. We look forward to a successful interactive seminar today. My best wishes to all of you. Thank you very much.
Thank you very much, sir. Now, may I request the President IMC, Mr. Shailesh Reddy, to formally welcome our Chief Guest, Honorable Chief Justice, with a bouquet of flowers and a memento, please. Thank you very much. Thank you very much, sir. Now may I request the Honorable Chief Justice, Mr. Mohit Shah, to please release the knowledge paper. Now, there is a knowledge paper developed by Ernst & Young, our knowledge partner. We request the Chief Justice to kindly release the knowledge paper. Thank you, sir. And now we come to the inaugural address by the Chief Guest, the Honorable Chief Justice, Mr. Mohit Shah. May I request him to kindly give us inaugural address. Thank you, sir.
President of the Indian Merchants Chamber, Mr. Shaunak Thakur, Chairman Law Committee of the Indian Merchants Chamber, Mr. Arvind Pradhan, Director General of the Indian Merchants Chamber, distinguished members of the Indian Merchants Chamber, dear delegates, invitees, ladies and gentlemen. It's indeed a pleasure to inaugurate the conference on Companies Act organized by the Indian Merchants Chamber. August 2013 indeed marks a historic moment and the beginning of a new era for corporate India. I must congratulate the President and members of the Indian Merchants Chamber for taking this initiative to organize the conference within the shortest possible time. In fact, within less than 24 hours from the time the President had given the Senate. This will certainly sensitize not only the members of the IMC but also the corporate executives, chartered accountants, company secretaries, lawyers and judges like me. Around 6 decades back, we had this Companies Act 1956. There were so many attempts for revision, but they were always patchworks and never satisfied the corporate world. So I'm very happy that the Parliament has taken this initiative and the President has given the assent yesterday. I must acknowledge that I have learned company law from a professor from Bombay, Professor M.J. Shetna. I was doing my second law in MS University, Baroda. Companies Act was one of our subjects. But those days, Professor M.J. Shetna would come from Bombay to teach LLM students. He would, naturally being from Bombay, he would not be there for the entire year. But for 10 to 15 days in a year, sometime in March, April, he would come to Baroda and deliver lectures to the LLM students early in the morning from 7:30 to 9:30. And though I was in the second LLB, I had heard so much about him. Professor Shetna had such great reputation. I was always a late riser, but to listen to Professor Shetna, I woke up early in the morning and I would go and attend all his lectures religiously. And I think I must therefore acknowledge my debt to this professor from Bombay, Professor M.J. Shetna. The company law has been rewritten extensively with several new provisions for investor protection, better corporate governance, and corporate social responsibility. The other salient features of the new Act are transparency in corporate governance, accountability in corporate governance, introduction of e-corp governance like maintenance and inspection of documents, keeping books of accounts, financial statements in electronic form, holding board meetings through video conferencing and voting through electronic means. Let me therefore take this opportunity to inform this August gathering about the e-governance initiatives taken by the Bombay High Court also in the recent past. Very recently, on 15th August this month, we have introduced the first e-court, and that also incidentally is in company matters. So our company judge hears all cases in a paperless court. Initially, it has started with the merger, amalgamation and merger petitions. Slowly, all the company matters will be heard by the company judge in the paperless court. We also have uploaded the judgments of national and international courts and journals and legislations, which are now readily available on the website of the e-library of the Bombay High Court. We also now hold meetings of the full courts because we have benches at Nagpur, Aurangabad and Goa. It is not possible to call all the judges to Bombay for the meetings because all the judges come to Bombay only once in a year for a meeting in congregation. So all our meetings, other meetings which are once or twice or thrice a month. They are held through the video conferencing. We have also introduced centralized filing system for the convenience of the litigants and advocates. So from 2nd September, from this Monday, all the cases will be centrally filed and digitized. We are also going to provide the service of communicating to the lawyers and litigants about office objections through emails instead of their coming to us, their clerks coming to our staff and taking a lot of time for removal of office objections. We are also going to introduce the system of SMS alerts. Very often what happens is that there are 20-25 courts at in different corners of the High Court building. The lawyers would not be knowing which case is being called out in which court. So now we are going to introduce a system of SMS alerts. Text messages will be sent to the lawyers that case number 5 in the board of judge so and so is going on has just started. So the lawyer whose case is at serial number 10 will come to know that all right, now he will be have to be ready to go to the court where his case is going to be called out. We must also point out to this August gathering the heavy responsibilities on the courts in the state of Maharashtra and the state of Goa, for both of which states the Bombay High Court is the common High Court. In the state of Maharashtra alone, when I came here in June 2010, we had 41,35,000 cases. Because of the efforts put in by our judges and with the cooperation of lawyers, that number has gone down from 41,35,000 to 29,87,000 cases. I must also inform the business community that there was a great problem about pendency of cases under Section 138 of the Negotiable Instruments Act, the check bouncing cases. When I came here, we had 3,27,000 cases. In the last 3 years, another 2,45,000 cases came to be added. So we had to deal with a load of about 5,70,000 cases. I am happy to inform you that in the last 3 years, we have disposed of 4,74,000 cases. So the pendency has come down to only 99,000. From 3,27,000 cases plus another 2,50,000 cases added, but now the pendency is only 99,000 cases. In the entire state of Maharashtra also, the pendency of these cases has come down to less than 50%. So I'm sure we have for this purpose, of course, also received the cooperation of the litigants and the lawyers through Lok Adalats and the mediation movement. And also, I'm also happy to inform you that in Maharashtra, now the success of the mediation is 54%. So out of 100 cases that were referred to the mediation centers, 54 cases could be settled. So please cooperate, extend your cooperation for mediation activity also, which will help you to resolve the cases as early as possible. I must also bring it to the notice of the August gathering that in arbitration matters also we have made considerable progress. When I came here, there were more than 570 arbitration applications pending, which applications were for appointment of arbitrators. So in the last 3 years, in more than 1,500 cases, we have appointed arbitrators. So that application also pendency has come down to only 75. Applications are filed, people want to file reply. So otherwise the applications are disposed of within 3 to 6 months. Coming to the subject proper, company law in India can be traced back to the Companies Act 1866. Then we had this Companies Act of 1956. The groundwork for the new Companies Act was started in 2005 with the report of Mr. J.J. Irani, as was informed by the President. The Companies Act will give this country a modern legislation which will contribute to the growth and development of the corporate sector in India. The new law will attempt to meet with the requirements of a dynamic economy and facilitate the development of a business-friendly environment in India. It aims at creating a congenial atmosphere which will foster the growth of business and add to investor confidence by creating a regime of certainty and clarity in the regulatory landscape. The new legislation will have far-reaching consequences, and the changes so brought about will affect various sections, including companies, both listed and unlisted, shareholders, directors, auditors, and other players in the corporate milieu. The companies bill has been in the news for quite some time as a much-awaited piece of legislation which would align the Indian corporate laws with global standards. It is expected that this new legislation would enhance the standards of corporate governance, disclosure standards, and regulatory oversight. After a long wait, we are finally very close to the culmination of this dream into a reality. The object of the new legislation is to ensure transparency within the corporate system. It stresses on transparency in financial reporting, improvement in corporate governance norms, enhancement in accountability on part of corporates and auditors, and protection of interests of small investors. A novel inclusion is that the new law would require companies that meet certain set criteria to spend a portion of their average profits in the last 3 years towards corporate social responsibility activities. The Act has inbuilt provisions which would facilitate ease of doing business in India, as the Act empowers companies to function in a manner which is self-regulated and is driven by disclosure norms rather than a government approval-based regime. It is very important to note that the Act now envisages shareholder activism and a concrete mechanism of regulatory oversight to control corporate frauds. Special emphasis has been laid upon protection of interests of investors in a company and to safeguard their rights. The lawmakers have naturally learned from the past experiences and have attempted to bring into force an effective regime to deal with these situations which have rattled the corporate sector in the past. For the first time, the term fraud has been defined. Stringent penalties have been provided for persons found guilty of fraud. In cases where deposits are accepted with intent to defraud the depositors or for any fraudulent purpose, the officers concerned will be held personally responsible, and I think this is very necessary. One of the most discussed provisions of the new Act is the class action mechanism set out under the new Act. Class action procedures form an integral part of the jurisprudence of Western countries. Despite the popularity of such actions in countries such as the United States of America, such shareholder actions are rarely undertaken in India. Though the Civil Procedure Code since 1908 provides for representative actions, the inclusion of a specific class action mechanism under the new law is indeed a welcome development. Class action is covered under the heading Prevention of Operation and Mismanagement and gives right to a prescribed number of members or depositors to file a class action. Inter alia, to restrain a company from committing an act which is ultra vires the chartered documents, to restrain the company from doing an act which is contrary to law, and to claim damages or compensation from the company, its directors and auditors for fraudulent, unlawful or wrongful act of conduct. Sitting as a judge of the Gujarat High Court, I had an occasion to deal with a case sometime in 2004. The fluctuating rate notes were issued by a company and there were defaults. One of the note holders, having substantial number of notes, filed a winding up petition in the High Court. And the defense raised by the company was that, sir, only the trustees can give a discharge. So, this individual note holder has no right to file a winding up petition. They relied on a judgment of a British court which was rendered in 1879 and which was still considered to be a leading judgment. The Chancery Court in Uruguay Central and Higueritas Railway Company of Montevideo in the year 1879 had held that a debenture holder did not have an immediate right of action for money lent or money due because the company is liable to pay the trustees under the deed and therefore the company cannot be sued twice over. They said if an individual creditor is allowed to sue the company And thereafter, if the trustees also sue, there will be double action. So this is what they did. Allowing the debenture holder to sue the company would require the company to face two actions, one by the trustees and the other by the holder of the coupon. It does not appear that it was the intention of the parties, which is after all the governing rule in deciding the questions. Hence, the holder of a coupon, note or debenture, is not a creditor either at law or in equity within the meaning of the Companies Act. This judgment given in 1879 was holding the field, and I had to deal with the preliminary objection of the company that in view of this judgment, the debenture holder, the note holder had no right. So what was to be done? I could not have overruled the principle which had held the field for the last more than 125 years. I found out a way. I said the debenture holder, the note holder, should be allowed to file the winding up petition if he joins the trustees as a party. So once the trustees are also before the court, there is no difficulty of having two actions. In the same action, the rights of all the parties can be decided. I also found out that the judgment which was considered as the locus classicus on this principle began with the words that in this case we did not receive proper assistance from the lawyers. So that judgment was holding the field for 125 years, and therefore I found out this solution. So it is hoped that with this new act providing for class action, it will be now easier for the debenture holders and such other creditors, shareholders also, to sue the company for all the necessary remedies. Keeping in mind the principles of transparency and accountability, the Act makes provisions for rotation of auditors who are bestowed with the duty to protect the interest of investors in a company. Auditors would be held liable if they knowingly or recklessly omit certain information from the reports, thus strengthening the system of checks and balances. The role and position of independent directors has always been a subject matter of debate and discussion. The issue is immensely important since independent directors safeguard the interest of the shareholders of a company. The term independent director has been clearly defined in the Act, which now throws light on various aspects like the minimum number, tenure, remuneration, etc. of the independent directors and attempts to bring in clarity on this subject. The Act spells out specifically the duties expected of directors of a company. I am also happy to note that the Parliament has now provided for appointment of professional liquidators so that the liquidation proceedings in relation to small companies can be expedited. Earlier, the experience was that if a winding up petition is filed, it is admitted, and even if it is allowed within a year or two, the actual winding up proceedings would never come to an end. And therefore, as a lawyer, I would always tell my lawyers who are exclusively practicing on the company side that you are very lucky fellows. So you would ask why. A close friend of mine was practicing exclusively on the company side. And I told him that you are very lucky. So he said, why? I said, you are like a doctor, the dermatologist, the skin specialist. Skin specialists have three advantages. There is no emergency. So that is also the advantage which the company lawyers have. Nobody wakes them up in the middle of the night to get an injunction. Second emergency is that, second advantage of a skin specialist is that the patient never dies because of the skin disease. So the company matters also never are closed. And the third advantage is that the patient is never cured. So this appointment of professional liquidator, I think, will now take away these advantages which the company lawyers were hitherto enjoying. The Act also provides for constitution of the National Company Law Tribunal and an appellate tribunal known as the National Company Law Appellate Tribunal. A specialized adjudicatory mechanism has been contemplated with both judicial members and technical experts having experience in the corporate field presiding over specific disputes. I hope that there is also a special tribunal to deal with the economic offences under the Companies Act, because with what has happened in the United States, that a person found guilty of insider trading could be convicted within a year of the crime having been committed I think people are now expecting the same speed and efficiency with which the system is working in other countries. This will foster specialization, provide for a time-sensitive dispute resolution mechanism, and reduce burden on the regular courts. I have already informed you about the statistics of the pendency of cases that we have. The government has been empowered to constitute special courts to ensure speedy trials and disposal of cases. A special court shall consist of a single judge who shall be appointed by the central government with the concurrence of the Chief Justice of the jurisdictional High Court. A specialized agency for investigation of company-related frauds, like serious fraud investigation officer, have also been provided for under the Act. The New Companies Act is thus the result of detailed consultative process adopted by the government. It is therefore a move in the right direction. It is a structure which has evolved out of the experience gained over a number of decades and which now provides for an effective regulatory mechanism. It is an experiment embodied with a forward-looking approach and aimed towards progressive development of the Indian economy. However, the impact of the new legislation on the functioning of the businesses will be clear after the rules and regulations are framed under this enactment. The Companies Act 2013 is thus going to change the way companies are incorporated, they raise money and interact with stakeholders, govern themselves and contribute to the nation building. The very fact that the history of the business world changed upon adoption of this concept of formation of a company with limited liability. It is since then that the business structure, business world has completely changed. So I'm sure that with this new change, with this new legislation in the Indian legal and regulatory landscape, this will be the first step which I hope also becomes a giant leap for corporate law jurisprudence. I'm very happy that the organizers have selected very important topics for discussion at various technical sessions of the conference today. I'm also conscious of the fact that those who are not good enough to speak in the technical sessions are usually invited to inaugurate the conference. I'm happy to inaugurate the conference and thank you for inviting me.
Thank you very much, sir, for a brilliant address. I now invite Mr. Shonak Thakkar, Chairman of the Law Committee of IMC, to please propose a vote of thanks.
President Sailesh Vaidya of the Indian Merchants Chamber, Honorable Chief Guest, the Honorable Chief Justice of the Bombay High Court, Mr. Justice Mohit Shah, Director General Arvind Pradhan, and ladies and gentlemen. On behalf of the Indian Merchants Chamber and as the Chairman of the Law Committee of the IMC, it has been my privilege to organize this conference on the Companies Act 2013. And it has been a greater privilege that it should have been inaugurated today by none less than the Honorable Chief Justice of the Bombay High Court. On behalf of the IMC and my committee, I thank the Chief Justice for being with us today and inaugurating this conference. We are also privileged that several distinguished experts have agreed to join us today to share with us their expertise and views on this new legislation. The liberalization policies announced by the Government of India with a view to increasing economic growth has resulted in attracting the interest of a large number of foreign investors and foreign corporates to come to India to do business. This has resulted in enactment of several new statutes, the Competition Act, the Arbitration Act, the Electricity Act 2003, and yesterday we got a new act, the Companies Act. It still remains to be notified, but it has been signed by the President. The laws of a country and the spirit with which they are interpreted and implemented reflect the culture and mindset of a people that inhabit that country. Business laws are no exception. Business laws have to be capable of nurturing and facilitating the needs of business. They have to be dynamic in a changing world environment. The laws also need to adapt in order to meet regulatory challenges of the rapidly changing business environment and the needs of society in which the businesses operate. I firmly believe that the growth of business and industry will create both the demand and the supply for goods and services. It is the growth of business and industry which will create employment and wealth. It will be the growth of business and industry that will create prosperity, and which will eventually make our country strong and self-reliant and our currency stronger. To achieve this purpose, we need progressive laws and effective implementation with a positive spirit and attitude focused on the creation of welfare of the people. Since the key to creation and sustenance of strong growth in business and industry are progressive laws and their good implementation, the Law Committee embarked this year upon a program to hold a series of conferences and workshops aimed at discussing, analyzing, reviewing our existing laws with a view to identifying which of these laws need some changes and which need better implementation in order to achieve growth for our industries and our business. We have called this series the Laws for Progress. At the conclusion of each of these conferences and workshops, we intend to formulate a paper or recommendations to be submitted to the Government of India. The present conference is the first of the series of these conferences and workshops, and it will be followed in the coming months on other acts. We will shortly be having one on the Competition Act and another on amalgamation and mergers under the New Companies Act and the role of SEBI. I welcome all of you to participate in these conferences. Interested people, may I request you to please drop in your visiting cards. There will be a fishbowl kept outside for that purpose. We started this series with this new company law that the Parliament has recently passed, because it holds great promise and challenges for the progress of our corporate world. The corporate entities today have become organizations which go beyond the borders of a country in which they are incorporated. Their businesses and activities, their policies, their products and services, and their profits affect not only the economies and the society of the country in which they originate, but are capable of affecting and influencing societies and governments beyond the country of their origin. The laws governing and regulating activities of corporates has undergone changes in the United Kingdom and the EU countries in recent times. The Indian government has not lagged far behind to address the needs of Indian business. This new law on the Companies Bill consolidates and introduces many new concepts in the corporate world. It holds many promises and throws up numerous opportunities. It's designed to facilitate growth of business and at the same time to protect the interests of several classes of persons, some of whom are involved in the business activities and some of whom are affected by the business activities. They include the entrepreneurs, the managers, the numerous investors whose monies are involved, the banks and financial institutions, the employees, the environment, and the citizen who are affected by the business activities of corporates. This new law will touch the heart of all organized economic activity in our country, both economically and socially. So today, we are all gathered here with a common objective to understand, analyze and appreciate the nuances of this new Companies Act. Our chief guest, the Honorable Chief Justice of Bombay, has given us an excellent overview of this new legislation, and I welcome all of you to actively participate in this seminar. I thank our Chief Justice, the Honorable Chief Justice of Bombay High Court, for his support and in this initiative and inaugurating this seminar. On behalf of the IMC and the Law Committee, I also wish to acknowledge and thank our knowledge partners, Mrs. Ernst & Young, the ITC for sponsoring this conference. I also thank the media for their presence here and the support that they have always given to the Indian Merchants Chamber. Thank you.
Well, thank you very much. We will begin we'll have a tea break now and begin the session at 11:15. Thank you. All to please take the seats. We now have a session The session chairperson is Mr. Shaunak Thakkar. And the session would be on Intercorporate Loans and Investments by Mr. Bharat Vasani, Group General Counsel of the Tata Sons Limited. May I introduce to you the session chairperson, Mr. Shaunak Thakkar. He has a very leading counsel, practicing for the past 3 decades in the Bombay High Court and the Supreme Court. He has a practice which includes litigation, covers advisory works. He has been advising and representing companies, government companies, banks, mutual funds, NBFCs. And he is also a managing committee member of the Indian Merchants Chamber, a chairman of the Law Review Reforms and Rationalization Committee, a member of managing committee of the Bombay Bar Association, an independent director, etc., etc. The list goes on. So, Mr. Shaunak Thakkar will be the chairperson of this session, and I request him to please take over and start the discussions. Thank you.
Good morning and welcome everybody to today's conference on the Company Law Act 2013 organized by the Indian Merchants Chamber. It gives me great pleasure to introduce to you Mr. Bharat Vasani, the first speaker of today's conference. He is going to talk to us on intercorporate loans and investments. Mr. Bharat Vasani is the General Counsel for the Tata Group, a position that he has held since December 2000. He is currently a director on several boards of directors of companies. He has over 3 decades of senior management experience and has the most diverse corporate legal experiences which cover large international mergers and acquisitions, joint ventures and collaborations, corporate restructuring and negotiation of commercial contracts. He is highly regarded in government circles and in various chambers of commerce for his proactive approach on public policy measures. His views have been sought by the Government of India on diverse matters, including the Companies Bill and the making of the present Act, on the Competition Act and several other new legislations. He has considerable experience and knowledge of corporate laws of different jurisdictions and has participated in several conferences and training programs at the Harvard School and the Harvard Business School. I now present to you Mr. Bharat Vasani.
Very good morning to all of you. Honorable Chief Justice of the Bombay High Court and other dignitaries and all the participants here. I would try to give you first some broad overview and the context setting before I get into the technical topic of these loans and investments. My association with the reform of the company law goes back when I graduated in the year 1978 when there was Justice Rajendra Sachar Committee report. And they felt the need that 56 Act had outlived the utility in 1978. So we had in 2013, so it took such a long time. Because let me tell you that it's very coincidental. When the 48 Act, the 1956 Act was enacted, the chairman of the expert committee was Mr. Bhabha, one Parsi, and this time was Dr. Irani.